May I please, Your Lordship, I beg to mention item 6, Your Lordship.
Item number?
6, Your Lordship.
Your Lordship, I'm for respondent 2 and 3.
Your objection.
No.
Kindly accommodate us 3 weeks time,
6
Your
and 7
Lordship.
connected.
Yes, Your Lordship.
Yes, connected. Yes?
Kindly accommodate us 3 weeks time, Your Lordship.
Okay. It's 2 weeks.
3 weeks, Your Lordship.
3 weeks, why?
The conducting counsel will be back till the end of the month, Your Lordship.
Okay. 3 weeks is... Mr. Siddiqui?
Yes, Your Lordship.
Yes.
Much obliged, Your Lordship.
Your Lordship, I beg to mention item number 17.
What's that? My lords. Yes, Mr. Pandit. My lords, I have obtained instructions on the matter, my lords, and even though the prayer seemed very innocuous in the beginning, lordship, but it is more complex than that. The department is taking a stand that revised return at this stage is not permissible. Lordships. What to do?
So that may be, but Miles will notice that this was a direction of the CIT as well as the ITAT. This was never raised before them. They have not even challenged those orders. There is a direction from the ITAT that I may be permitted to file my revised return. This has never been challenged.
Where's the order?
Order
ITAT order is 190, page number 191.
I'm referring to the ITAT order 190, yes. It starts from page 189. Para 7.
189 para 7.
Para 7. My lord has it?
Yes.
We observe that the learned CIT appeals did not deny the claim of the SSE. The learned CIT appeal also did not deny that the SSE had not reduced the profit amount of so-and-so by way of deduction. The learned CIT appeals has held that the SSE can file a revised return if he has made a mistake. In our opinion, the learned CIT appeal has correctly made his observation. It is not the case of the SSE that he has filed revised return and the same is rejected by the revenue. Why not the SSE filed revised return so as to correct his mistake? Now please take note of this line, my lords. Therefore, this issue we hold against the SSE. However, we direct the learned CPC/CIT appeals to consider the revised return if filed by the SSE on the issue. This has never been challenged.
So if filed by the SSE on the issue, lordship, the question is filing of revised return.
So even as on this date, there was no option available to me to file it online. They could have raised this option. They could have raised this argument before.
So in such situations, what does the income tax authorities do? Now you can't accept anything offline. We cannot. It is go central processing center, whatever. As per section 139(5), my lords, which covers filing of revised return. The time period is 3 months prior to the end of assessment year or till the assessment is complete. In this case, that is long gone. So which year? So
the assessment is with regard to 21-22. But notice, I'm assuming that the ITAT was well aware of the fact that under subsection 5, the time period had expired.
If physical returns are filed, how will you reconcile them with the... Suppose we allow that we file physical returns. revised returns. And how they can be reconciled with your central processing system? It can't. There's no.
It cannot be reconciled.
There's a window where it can be accommodated.
No. Yeah.
Then where would he go then?
I'm sure if there is an order of this honorable court, there's a judicial order, they will find a way.
We have to examine first. There has to be a practical order that is, that's implementable, not something like will crash the whole system.
My lord, I understand.
My lords, I had taken instruction precisely on this point, whether if the honorable court passes an order, what will be the status of that order, whether it can be implemented. And the department is very, very categorical that it
cannot.
It's impossible because the system will not accept it. That's it.
Is this the first instance this kind of situations ever arisen?
It seems. I'm not aware of the other reasons, but in the northeast, it seems it is the first.
Find out. There has to be a window. It can't be that this is just one-off case that that he's left remediless in spite of the receiving this order that he may file his revised returns. So since he could not file, that's why he's come and said that let me file a physical return. So we're back to square one.
I'm afraid it looks like that, my lords.
It's not his fault. It's been rejected, we understand, but he's been allowed.
My lord.
And I was not ruling in favor of the SEC, but he's permitted to file revised return. He said they have not ruled in his favor also.
They have not.
There's no
filed by the SEC.
Anyway, you don't know much about how your system operates. We can't. We have to have informed kind of instructions.
My lords,
these kind of cases, you have to assist the court.
My lords, I've had detailed discussion with the officers, my lords, and they are of the view that it is impossible to incorporate this revised return into the system.
Reconcile with the.
That's what the instruction I have received, my lord.
We'll give you some more time. You just find out any other case which is similar and whether it's rejected and what was the consequences of that. Because what he says is correct. You have not challenged this where he's been allowed also.
My lord, that's correct.
If you had put an objection there, that is not permissible in view of the system that's operating, then it would end it there. Whether he's been wrongly assessed or incorrectly assessed, that is bad luck.
My lord, yeah. My lord, the only confusion with regards to the order is if filed by the SSC on the issue, my lord. That is.
If filed, that means how we direct the CPC AO. Now, even then, he's given 2 forums for assessment to consider the revised returns if filed by the SSC on the issue. So why won't he file? He's been given, What's he's been given?
My lord.
Then what to do?
I leave it to the discretion of the honorable court.
Today has submitted for this court that as per instructions received, the filing of physical returns is not permissible, as the same cannot be reconciled with the what's that central processing? What did they call it?
Central processing system.
Central.
My lords, CPC, I think what's that called?
Must be somewhere here.
Is it shown?
Yeah, it must be somewhere.
Centralized processing
Central processing system.
Yes, can be reconciled with the data in the centralized processing center. He therefore submits that the prayer of the writ petitioner cannot be acceded to by the income tax authorities. Not take down. On hearing the learned counsel, this court notes that in the order dated, where is this filed by income tax appellate tribunal? Dated
at page 187, order dated 25/10/24.
In the order dated
25/10/24.
25/10/24, passed by the income tax appellate tribunal. The writ petitioner had at para 7 of the order thereof been given opportunity to file revised returns. Stop. It is also noted that on its inability to file the same online, the incident petition had been filed seeking liberty to file or seeking orders to allow the SSC to file by physically. Stop. In this view of the matter and the situation as it pertains as on today, Ms. Aspandi is directed to obtain further instructions as to whether such a situation has occurred before allow the court to go further in the matter.
Lordship.
Yes.
Okay, Lordship.
Yes, after 2 weeks.
Item number 2.
Must be some other thing.
May it plead your lordship. Lordship, the petitioner's case is that against the adjudication order, we have filed an appeal with a condonation of delay as well as a stay petition for dispensing of the deposit amount. We have filed that petition before the income tax authorities, lordship. Now, for that, no date has been fixed yet, and there is a condonation, so it will take some time also. So we have come to the High Court with a limited prayer that till that is considered, no recovery proceedings may be done, no coercive action.
But you already given those orders. I think interim orders are already there in your favor.
Yes.
Then?
For coercive action, lordship has given. We are very pleased with that. The order for no coercive action has been given. But then after that, they have kept my bank account freezed, lordship. So my business for last 7-8 months has been on a halt, lordship. That is being very difficult. He is not being able to pay salaries to his staff and anything, and the amount of tax that they have calculated has no connectivity with my income, lordship. The return income which I have shown in my returns, whatever income I have shown, the total amount has been taken has been calculated as tax. That cannot be, lordship. The highest slab is also 30% only, lordship. So there are many loopholes in the order also, lordship.
But the appeal is pending, correct?
Yes.
Lordship, in fact, my lord, appeal was pending, and before filing appeal, my lord, that recovery proceeding was initiated and bank account has been frozen. And in fact, my lord, in the appeal, my lord, they have also filed in, my lord, the application for stay. In that application, they have categorically prayed for, my lord, for release of the bank account, my lord. And in fact, it is not like that, my lord, after filing of the writ petition, bank account has been frozen. That is not there, my lord. And in fact, my lord, we have filed our affidavit, my lord. We have challenged a very...
Panel, let's see.
Yes, my lord. We have challenged the very maintainability of the writ petition, lordship. Appeal is pending, my lord. Stay prayer is there, my lord. And for the same prayer, they have come before this honorable court, lordship. Now, see, we filed our affidavit, my lord. In our paragraph number 2, my lord, we have categorically stated, lordship. Para 3, my lord, my affidavit. Para 3, lordship. That before making para-wise replies to the various averments made in the present writ application, the answering respondent raised a preliminary objection about the maintainability of the present application filed under Article 226 of the Constitution of India by the petitioner. It is hereby submitted that against the assessment order that so-and-so passed under Section 148, read with 144, read with so-and-so, as well as demand notice dated so-and-so, the petitioner has preferred a statutory appeal under Section 246A of the Act before the Appellate Authority on 21/2/2025, that is Annexure 9 to the writ petition. Along with the said appeal filed on so-and-so, the petitioner has also filed an application praying for a stay of recovery of the outstanding demand of rupees so-and-so. Therefore, when the petitioner has already approached the Appellate Authority under Section so-and-so, present application filed before this honorable court on 24/2/25, that is within 3 days of filing appeal before the Appellate Authority, seeking the same relief is therefore not maintainable and liable to be dismissed. And in fact, lordship, when the appeal is pending, my lord, they may also file the my lord before the my lord assessing authority my lord for staying the recovery my lord. That is a specific provision is there under section 220 subsection 6 of the Income Tax Act my lord. In fact, they have not approached the assessing authority my lord, and there are mandatory requirement of 20% of the pre-deposits. Whatever amount lying with the bank my lord, that is much below the my lord that deposits of 20% my lord, and that has been clarified my lord when they have send a letter to the department after passing of my lord, the interim order passed by this honorable court. My lord. So, my lord, my humble prayer, my lord, this petition itself is not maintainable, my lord. And my lord, the Supreme Court has categorically said, my lord, when appeal is pending, my lord, it is the my lord the appellate authority who has to take the call, my lord. And they have the opportunity to file an application before the assessing authority under 226 lord.
Yes. We have to see maintainability.
Lord, I may place a judgment, Lordship, which squarely covers my case, my lord. It's a small judgment.
You want a copy to the council?
Lordship, I'll share with him, Lordship. It's a small judgment, Lordship. You can see here.
Yes.
May I read? It's a 3-page Lordship judgment, Lordship.
Yes.
The petitioner in WPC so-and-so is the appellant be herein aggrieved by the judgment dated so-and-so in the writ petition. The brief facts necessary for disposal of this writ appeal are as follows. The appellant had impugned exhibit so-and-so order before this court in the writ petition when confronted with recovery steps for recovery of the amounts confirmed against it by the order. It was the case of the appellant that against exhibit so-and-so order, he had preferred exhibit so-and-so appeal along with stay petition before the second respondent, the appellate authority. The appellant has also preferred application before the third respondent seeking out of turn hearing of the appeal. In the meantime, coercive steps were taken for realization of the demands. Therefore, the appellant preferred WPC before this court. The learned single judge disposed of the writ petition with a direction to the second respondent to consider and pass appropriate order on the stay application. The learned single judge, however, did not grant stay of recovery proceedings pending disposal of the stay petition by the state respondent. We have heard so and so. In our view, since the learned single judge had relegated the appellant to the alternative remedy before the statutory authority, it was incumbent upon the learned judge to protect the appellant from recovery proceedings pending disposal of the petitions by the respondent appellate authority. Accordingly, we modify the impugned judgment of the learned single judge to the limited extent of clarifying that pending disposal of the stay petition or appeal, whichever is earlier by the appellate authority, the recovery proceedings against the appellant for recovery of amounts confirmed against it by order shall be kept in abeyance. Application for early hearing of appeal shall also be considered by the third respondents in accordance with law.
Yes, but in this matter, the question of maintainability is not answered. What has been raised by the respondent here?
My lord, in this case also we came in a writ petition after that, after filing the appeal and the stay and everything, lordship.
No, that is what I mean. In this order that you placed,
yes,
the question of maintainability is not been discussed at all. It's just a question of that maybe the order was wrong while he passed some orders that he should have protected you before the. Now the question of maintainability is not here at all.
Lordship, in this case it's a exactly similar situation. Therefore, it is maintainable, lordship, because my appeal and otherwise it will become infructuous, lordship. My writ petition will become infructuous if recovery is made before disposal of the stay and the application, lordship.
You can't have two parallel proceedings.
Lordship, because on last occasion, lordship, I have shown that the order suffers from principles of violation of
the assessment order.
Yes,
so that will not go there. The only thing is that you've come as writ jurisdictions extraordinary.
Yes.
So that's the only thing. So now, if you've already preferred an appeal, and in this case, if what they say in the affidavit is correct, now within 3 days of filing the appeal, you've come running to the writ court.
Yes, your
before any anything has happened there before the.
But lordship,
before in the appeal.
I may be.
So that is the question.
Is correct. Lordship
if you suppose the appeal is pending and like nothing was happening, maybe you would have had recourse to come to writ court and see nothing's happening and my accounts are frozen. I can't operate.
Lordship may kindly.
That is the only
lordship
thing.
Is absolutely correct.
Yes.
Lordship, only one thing is that if I have come to the writ court within 3 days, Lordship, but now within the proceedings also, Lordship, it has 7 months has passed, Lordship. They have not even fixed a date, or the officer has been appointed who will take up my appeal or anything. And stay of proceedings was never given by this High Court.
Because they also will be, apprehensive. That is why they're not giving you a date, if I understand correctly. Once the matter is pending before the division bench
But
here.
But Lordship has not given a stay of proceedings, Lordship.
You don't give stay of proceedings, even.
And Lordship, on the last occasion, I have shown Lordship how the assessment order has been passed. If Lordship takes up the affidavit, Lordship, page 11, Lordship. 7 days time was given. Page 11 of the affidavit they have filed, Lordship.
Mr. Chetia,
Lordship.
so how soon can you get these proceedings going?
Lordship,
Within 3 days?
Lordship, within 3 weeks, my lord.
We'll complete the proceedings.
No, not complete, my lord. First, their contestation application has to be decided, Lordship. It was filed after a year, Lordship.
Lordship, the whole thing may be disposed of in
Now,
2 months, Lordship. And till then,
where is it? Para 10, what do you want to show?
Lordship, page 11, Lordship.
Right, in the chart.
The chart, Lordship. The show cause notice was given on 1/2/2024. And only 7 days time was given, Lordship, to reply. 14 crores demand, Lordship. Is that possible, Lordship? And then they pass the order within 15 days.
First 24. Then adjournment granted.
Not first 24. It is wrong, Lordship. There is typographical error. Lordship may see on page 10, Lordship. Left hand side. The actual date is 1/2/24. In the chart, it is a typographical error, Lordship. And the order was passed on 19/2, Lordship, within 15 days.
So, Mr. Chetan, this is wrong. This
Lordship,
1, 2, 3, 4 lines in your chart.
My lord, that is whether my lord typographical error occurs in page 10 or 11. I have to, my lord, see the records, my lord. In fact, Lordship,
in the other case also like this, 15 days time.
No, Lordship. In fact, sir, your Lordship may see the chronology, Lordship. And in fact, my lord, it was relating to the assessment year 2016-17, my lord. And this notice was issued, my lord, on even assuming, my lord, that is 1/2/2024, my lord. The record has to be produced in respect of the assessment year 2016-17, my lord. And thereafter, another opportunity was granted on, my lord, 16/2, Lordship.
Lordship, in
So they have never appeared, my lord.
Lordship, in total, it is 15
which
days.
Should we take? Is it 1, 2, where are the records? Have you annexed it here?
Lordship.
Copy the notice.
That is not there, Lordship.
So annexed in your petition.
No, Lordship. This notice I have not received only. That's why I could not reply. It's not in the portal also, Lordship.
No, Lordship.
It's not there on the portal, Lordship. I have checked the portal because last day when I argued, that's why I went back and I checked the portal.
My lord.
And how the court determine which is correct? Because if it's 1/1, then mean if it's 1/2, that means there's some,
Lordship,
Lordship,
this
in the other
application,
case,
they have not challenged, my lord, praying for a writ of certiorari, my lord. They have not challenged the assessment order before your lordships.
It's a question challenging. It's a question of the seeking.
I cannot challenge
This is
both
like a big
places.
stay order as well.
My lord,
stay application.
My lord, only thing, my lord, in a similar circumstances, my lord, your lordship may kindly see, my lord, the observations of the Honorable, my lord, Supreme Court and other courts, lordship. Lordship, this is...
Lordship, here 1 minute. Lordship, I may interrupt 1 minute. Lordship, sometimes he's arguing on the merit and sometimes he's arguing on the maintainability. He may choose one thing.
First, Lordship, maintainability has to be decided, my lord.
He's answering your question with regard to that show causes. But then it's not done on the portal also. I mean,
it must be there, lordship. It must be there.
Then
everything is on the portal,
lordship.
lordship.
It in your affidavit.
Lordship, I'll annex, lordship.
Lordship, this way only 7 months my petitioner is suffering. He cannot pay the salary or anything. Lordship, the revenue will not suffer. My only thing is that
revenue suffers. The question, the proceedings should proceed. This all.
Yes, lordship.
In accordance with law.
In 3 months they can dispose of my whole appeal, lordship. Only till then he may be allowed.
What do you want to show from here?
My lord, the maintainability of the writ petition, lordship. Lordship, the 2014-1 SSC 603, my lord, relevant portion at page 6, lordship, para 19. Page number 6, lordship, does.
Yes, sir.
Lordship, this is 2014-1 SSC 603, Supreme Court, lordship.
Para 4.
Para 19, page number 6.
Yes. Okay. Yes.
Thus, while it can be said that this court has recognized some expectation to the rule of alternative remedy, that is where the statutory authority has not acted in accordance with the provisions of the enactment in question or in defiance of the fundamental principle of judicial procedure, or has resorted to invoke the provisions which are repealed, or when an order has been passed in total violation of the principle of natural justice, the proposition laid down in the so-and-so cases and other similar judgments, that the High Court will not entertain a petition under Article 226 of the Constitution if an efficacious alternative remedy is available to the
income tax matter, or it's a general decision?
Lordship. It is Lordship tax matter, Lordship.
Tax matter.
Lordship. It is same, my Lord. 148 proceeding, my Lord.
See, Mr. Chetia, before we go ahead with the matter, we only want confirmation with regard to that show cause. If that show cause was shown as 1/2/2024, then maybe there are exceptional circumstances, because jurisdiction will not exercise unless the exceptional circumstances where discretionary powers will be used by this court. Because that is as given that where the statutory appeals and alternate remedy both interfere. Now especially stricter with that side proceedings or debt recovery proceedings or these kind of any to do public revenue. So that's the only thing. So we have to satisfy ourselves that that whatever they've put here before this court regarding the the circumstances, that's the only thing which we have to be satisfied with. You will register on Tuesday. You come with the confirmation.
Lordship, and next week.
Otherwise, then if we feel that yes, they have placed enough.
My Lord, in fact, my Lord, my humble prayer, my Lord.
Yeah.
When, my Lord, they have already filed an appeal, my Lord, and it is a subject matter.
That's fine. That is the well and
And
good.
specifically, my Lord, they have not prayed for a writ of certiorari, Lordship. Their limited prayer is, my Lord, till the condemnation petition is taken up by the appellate authority, your Lordship may grant a stay order of the recovery proceeding. That was their limited prayer. So, under that circumstances,
I understand. That's why we're saying this writ petition is nothing but it's just a stay application.
Lordship. Lordship, next Tuesday, my Lord, I will file an additional affidavit.
Let me file additional affidavit Tuesday. Yes, Mr. Chetia, Learned Counsel for the Income Tax Authorities has.
My Lord, may I make one small prayer?
Yes.
If my friend agrees. There are so many, they have quoted 3-4 bank accounts, Lordship. At least one may be allowed to operate so that his business may not
Tuesday
stop.
we'll dispose the matter finally. Yes. Yes, Mr. S. Chetia, Learned Counsel for the Income Tax Authority for the respondents number
2, 3, and 4, my Lord.
2, 3, and 4 has submitted that, has questioned the utility of the preliminary petition and has submitted that against the assessment orders. The petitioners already preferred an appeal. And in fact, within 3 days of filing the appeal, has approached this court seeking interim relief against recovery. He submits that the same is not permissible and prays that the matter will be dismissed on the ground alone. MSS Gope, however, in reply has submitted that the circumstances in which the petitioners approached this court is that though the period given for show cause was extremely short, and which prevented the writ petitioner from replying to the same stuff.
And my lord, 1617 is time barred also. The proceedings is time barred.
Learned Counsel also submitted that apart from the appeals being time barred, the chart given in the affidavit of the respondents 2, 3, and 4 is unclear as to on which date was the show cause notice issued. So she maintains that the show cause was issued on 1/2/2024 with the, where's that chart?
Page 11 of the affidavit, lordship.
With
Date of compliance 8/2/2024.
with the date of compliance, given on 8/2/2024
and 19/2/2024, 15 days.
19/2/2024. Stop. Ms. S. Chetia submits that the date given, that is 1/1/24, is correct. However, he fairly submits that he has not annexed the said show cause notice to the affidavit. Stop. Because in these circumstances, in order to enable the court to determine the correct factual position, Mr. Chetia is permitted to bring on record the show cause notice and to as to whether it was issued on 1/1/24 or 1/2/24. Just on Tuesday.
Lordship, may kindly observe that maintainability question is left open, Lordship.
Of course.
Will kindly be recorded when at least my submission, Lordship.
Question will be decided finally on the next date.
Deeply applies,
Lordship, lordship, the interim earlier.
Interim orders of initial continue.
Item number 4.
May I please, Lord? My Lord, in item number 5, I am appearing on behalf of respondent number 2 and 3, my Lord. Kindly grant, my Lord, 3 weeks time to file our affidavit, my Lord.
Is the matter same?
Lordship, this is an income tax matter, Lordship.
Okay, Mr. S. Chetia, counsel for respondents 2 and 3. Is forms allowed? How much
3
time?
weeks, Lord.
For the 3 weeks time for affidavit. Interim orders of initial continue.
Highly grateful, Lordship.
Oblige.
Item number 8.
England. England.
Lordship, in this matter,
Yes, Mr. Amkan. Yes.
yes.
Item 8 is JB Textile.
My Lord, if the next matter can be taken up, 15.9.
The agency.
WPC 15.
Arabic journals in London. You know.
Is a tax matter.
My Lord, I am ready with the hearing, my Lord.
No, who, Mr. Arabic journals appear in which matter?
Number 9.
I am appearing to the respondent, Lord. Yes, Lord.
Number 8.
What is that?
Lord, may have it after 2 weeks, Lord, these matters. Physically,
Let him come back.
yes.
Yes, sir.
Is it?
Dr. Saraf, he's out. Let him come back. Will he come, please? On the request of the Advocate General, this is matter. When you're returning?
My Lord, after 27th, any day, my Lord.
Yes, this is a matter on. We listed on the 1st of July. Yes.
Yes,
Obliged.
Item 8, 10, my Lord, there are two matters, 10 and 11, my Lord.
Yes.
Two matters.
9.
My Lord, item 10, 11, my Lord.
Yes.
My Lord, interim order may continue, my Lord.
Interim orders, if any, should continue.
Take out offence. My Lord, this is the appellants have submitted their argument, and it's for me to reply, my Lord. The principle of equal pay for the equal work. So
what arguments are submitted?
My Lord, the appellants have concluded.
Two adjournments. So whatever is submitted also, if we forgotten.
My Lord, they have in fact submitted the written submissions also, the written arguments also, my Lord.
Yes.
So here, my Lord, the law regarding the equal pay for the equal work, my Lord, has been authoritatively set by the Supreme Court in the case of Jagjit Singh's case, my Lord. So in my humble submissions, my Lord, all those objections that has been raised, that the cause of actions cannot be clubbed together, or there's wholesale and wholesome and wholesale pleading has to be done, my Lord. These all are irrelevant as far so
irrelevant.
far. Irrelevant.
Answered by the judgment, you mean?
My Lord, so far as on the teeth of the Jagjit Singh's case, my Lord, all these arguments are irrelevant because Jagjit Singh has already set, my Lord, this law. Jagjit Singh's case says that no matter how you, it's not a question, my Lord, how you enter into the service, my Lord, and it is not also a question, my Lord, whether you are the only criteria, my Lord, is the functional. It's a functional duty, my Lord. It's a functional duty. Whether you are function.
Copy of the written argument.
That's a provision. Only one. But last time you gave me one copy.
I've already submitted, my Lord, the notes of. My Lord, yes.
Positive.
Yes, my Lord, I have. However, my Lord,
brother does not have it.
I have extra copies, my Lord. If I still have some more copies.
Just want to refresh
my Lord.
What arguments you made.
Also, we'll have to hear the matter again, my Lord, because it was a long time back.
Mr. Yubin was making tactical adjournments, that's why.
Not tactical, my Lord.
We have court was about to pass order, then you make tactical adjournment. Now we've forgotten everything.
My Lord, in that case, my Lord, let's fix a date, my Lord, when the Advocate General is back also. I will, in the meantime, I will also submit my written submissions.
This court observed that everything stems from the conditions of your employment and appointment.
My Lord, but the Jagjit Singh's case is very clear, my Lord. It says that no matter how you enter into the service, as long as you perform the same job, and that is an admitted, it is an undisputed fact.
We'll have it on 3rd of July.
3rd of July. 3rd of July.
As the Advocate General is not available in the country, this is matter on 4th of July, or 3rd of July. Yes. What will you do? But we'll complete it the next day. We won't let you go.
No, I'll complete, my Lord. I'll not escape. My Lord, I'm sorry.
Any mention?
Lordship, I beg to mention item 21, 22, Your Lordship, connected matters. Item 21 and
for the
22.
respondent.
Yes, Your Lordship. Respondent 3, Your Lordship. Lordship.
We are for the petitioner.
Yes, Lord.
No objection.
Your Lordship, let have after 1 week, Lordship.
Yeah, objection. No, he has. You are asking for time. He has.
Yes,
He's objected. Yeah. Okay, after 1 week.
Obliged, Lordship.
My Lord, I beg to mention, make a mention of item number 24, my Lord.
No objections.
My Lord, kindly allow us to file the affidavit of service in the course of the day, my Lord.
Why? It's not been served as yet.
My Lord, kindly allow us to file the affidavit, my Lord.
Unless after 2 weeks, petitioner will file after indicating service in the course of the day. Why is it come to hearing list then?
Lord.
My lords, it had come to the notice of my lords that a particular respondent number 8, was important for the matter. And
oh, then yes, okay.
Yes.
This matter of 2 weeks in the order column, petitioners is permitted to file after indicating service in the course of the day.
all right, my lords.
My Lord, I beg to mention item 29, my Lord. My Lord, the conducting counsel, Mr. Philemon Nungri, is on sanction leave. My Lord, I humbly pray the matter come up after 2 weeks, my Lord.
Yes.
No objection, Your Lordship.
Deeply obliged, my Lord.
Your Lordship, I beg to mention item number 19. Your Lordship, I'm praying for 1 week's time to file the additional affidavit.
What additional affidavit?
Your Lordship, here the question of tortious liability had come up, so we're tortious liability, Your Lordship.
Maintainability?
Tortious liability, Your Lordship.
Yes.
No objection, Your Lordship.
Yes, this matter of 2 weeks and respondent number, state respondents.
State respondents, Your Lordship.
To file affidavit, additional affidavit on with regard to
Tortious liability, Your Lordship.
liability has been raised by them.
Your Lordship, during the course of hearing, that question had come up.
To file affidavit on the question of tortious liability, as the same had come up during course of hearing on the earlier occasion. Yes.
Obliged, Your Lordship.
Mr. Lordship, I beg to mention item number 20, Lordship.
Why these matters? What
Yes,
remains?
the problem is that the conducting counsel is P.S. Nongri. She's the one who has some details, updates, directly with the claim.
And from our behalf also, Your Lordship, there's some development in this case. So, Your Lordship.
I have spoken to the counsel, Mr. Linda, also. He's also not keeping well. P.S. Nongri is also not keeping well. So, we'll just have it after 2 weeks, Lordship.
Yes.
Thank you. Lordship.
May I please, Your Lordship, I beg to mention item number 25, Lordship.
So all the matters are gone. Yes, 25.
Yes, Lordship. After 2 weeks, Lordship. 25. Yes, Lordship. Yes.
Yeah, objections, Abraham?
It's no objection, not bad. Basically, the fight is between the two wives.
And you're in between. Very good. 2 weeks, yes.
Thank you, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 26, madam.
You're for the petitioner?
Yes.
26, Pandey?
Yes, Pandey.
No objection?
No objection. Can you have the matter after 2 weeks? Obliged. Evening,
Please mention item number 5, my lord. Supplementary, item number 5.
Item number?
5, my lord. Supplementary.
Number?
5, my lord.
5 in the...
Supplementary list, my lord. Supplementary list.
The hearing is 5. 5 is
supplementary list, Your Lordship. Supplementary list.
Since leading question, leading counsel here is disposed, my lord.
5. Darbar Sinong Mensai.
Yeah, Mensai, my lord.
Why?
Because the leading question, leading counsel is disposed, my lord. And reports mechanic may take up on Monday, my lord.
After?
Monday, on Monday, my lord.
Monday?
Monday,
We'll have it next week, after 1 week.
Okay. Obliged, my lord.
Obliged, Your Lordship.
Yeah.
May I please, Your Lordship?
Your Lordship, I beg to mention item number 17 on behalf of my senior A.S. Siddiqui. Your Lordship, I pray for 4 weeks' time.
No objection, Lordship. I'm appearing on behalf of 4 to 8. For respondent 1 to 3.
Oblige, Your Lordship.
Yes.
Supplementary list item number 1.
May we please, Your Lordship. This is a contempt application, Your Lordship, for violation of this Honourable Court's order. If Your Lordship is turn to page 17.
Yes, sir.
Order dated 28/11/2018. This is with regard to medical allowance, house rent, house allowance, and winter allowance.
Order dated when?
On page 17, 28/11/2018.
Where's the page?
Page 17, that is Annexure 3 of our High Court. The relevant page at page 36, if Your Lordship.
What is dot since 2018?
This is with regard to the direction given, although this was in favor of
Contempt be maintainable now? More than how many years?
No. Thereafter, what happened? They paid. Then they went to Supreme Court. Supreme Court modified this Honourable High Court's order, but give the effect from 1/1/2018, not from the back. So 2018 till 2022, they paid. After payment, what happened? They filed a miscellaneous application to modify the Supreme Court order. Since the Supreme Court order is supposed to be modified, at last, then in the meantime, no stay was there. Then legal notice was issued by the association through the council. Then when it was, they replied that since miscellaneous application pending in Supreme Court, so we are not paying it. However, miscellaneous application has been disposed of at Annexure 8, page 66, if Your Lordship is pleased to, at Supreme Court. That was dismissed.
It will be a continuing, or you come with a fresh cause of action.
Yes, Lordship. This was dismissed, Your Lordship, page 66, if Your Lordship is pleased to. Lordship Counsel appeared, Senior Counsel for the State of Meghalaya, appearing for the applicant, sought permission to withdraw the miscellaneous application with liberty to pass appropriate order on the representation made by the respondent teachers. His submission placed on record, miscellaneous application dismissed as on withdrawn with this aforesaid liberty. So it was dismissed, but thereafter, from September 20th September 2024, no any liberty has been taken. They have not filed any case, but they are sleeping tight with the.
How will contempt be maintainable now?
It is within the period. It is 24th September 28th 2024. Now June, within 1 year we can file it.
Yes, sir. We will issue notice, let them reply. Yes. Heard Mr. S. I see the council will also issue notice returnable in 2 weeks. Steps to be taken by the suggested AD within 3 days. This also.
Deeply always.
Item number 2.
Please, Your Lordships. My Lord, this is a case, my Lord, where, my Lord, there is a boundary dispute between two villages, my Lord, Yalong village and Pasi village. Both falls under the jurisdiction of, my Lord, Alaka Juwai Doloi. Now, they have voluntarily submitted for redressal of the settlement of the dispute. Now, under the Act of 2015, my Lord, an amicable settlement, my Lord, the Doloi is empowered. So, settlement was done, Your Lordship, amicable settlement was done. That was done, my Lord, on 11th March 2021. So thereafter, my Lord, the settlement and physical demarcation was done. It was sent to the District Council. Now, District Council, my Lord, ultimately, my Lord, on, my Lord, 26th February 2024, acknowledged the settlement. When the situation was such, my Lord, suddenly, my Lord, without any shock cause, my Lord, without any opportunity of hearing, this order acknowledging the settlement by the District Council, that was withdrawn by a letter dated, my Lord, 15th May.
By whom?
By the District Council, 2024. Now, my Lord, what happened in the meantime, my Lord, so far my village is concerned, my Lord, Yalong village, my Lord, the election was pending. So after the election, my Lord, on the last part of, my Lord, 2023, Your Lordship, new body has taken over. Now, after that, we have found that a case has been filed, my Lord, by the Pasi village before this Honourable Court, challenging the acknowledgement granted by the District Council on the ground that they are not agreeable to the amicable settlement. So while the notice was issued, my lord, even the notice, my lord, was sent to us. But my lord, the election was pending, my lord, we are unable to take any steps. But before we entered appearance, my lord, a submission was made, my lord, that this order was withdrawn by the district council. So the matter was closed, no issue was decided. So my lord, my grievance here, my lord, this was withdrawn, my lord, without affording any opportunity of hearing. Other thing is this, my lord, this is an amicable settlement, now made in 21. Now subsequently, my lord, I have found out, my lord, some protest has been lodged by the new committee, my lord, new Darbar and the Waheshnong, who came into place in Pasi village, my lord, sometime in the year 2023. The new village, they did not agree. But so far, my lord, the settlement was concerned, my lord, that was done by the Darbar. So, my lord,
so then does it matter for the council to reassess?
Lordship, and other prayer is, my lord, even otherwise, my lord, they are under obligation.
Already come into a settlement.
Now only because
other villages regarding the boundary, and that has been, even what do you call it?
No, only because
the Dolai has already ordered on it and has gone for. How can they just be recalled like that?
Only because the new Darbar come, my lord, never things will never.
You cannot be like that.
If I can reply.
It's not correct.
It's not correct, Lordship. Because there was a settlement in Lordship between the two villages before the Doloi. Now the Doloi, Lordship, at page 35, page 129 of the writ petition.
129?
129, Lordship. This is the report of the Doloi, Lordship.
Yes.
There was a meeting between the two villages and with the Doloi, Lordship. Lordship, para 2, Lordship.
Yes.
It is decided to confer upon the Waheshnong of Yalong and Waheshnong Pasi to place the report of the Doloi of Ilaka Joai dated 11 March 21 before the executive body of the respective village for the purpose of their information and to be affirmed by them so that the peace will be prevailed in the future. Now, so far as Pasi is concerned, Lordship, they had placed the report before the Darbar. Now, the Darbar did not accept the report. Page 132, Lordship.
At that time, 21?
At that time, Lordship. Page 132.
121.
132.
Yeah. No, 132.
Now, this is the voice of the Darbar of Pasi, Lordship, saying that we do not accept the report of the Doloi, Lordship. Para 1, Lordship. All of the residents of Lat Celia are from Pasi village and they refuse to be resident of Yalong. So basically they don't want to be part of Yalong village. Now this was taken into consideration, Lordship. In the meanwhile,
where was it approved by the executive committee?
Lordship, 139.
And then
139, Lordship. This is the executive committee has recognized the boundaries of the petitioners
as per the arrangement.
As per
the report.
As per the
139.
129. 139.
Yes. Okay.
Lordship, then the Pasi village had approached this honorable court saying that they were not granted any opportunity while this letter was issued. So subsequently, Lordship, the EC has taken the decision to withdraw this 26 February 2024 and that the EC will decide afresh, Lordship, so far as the matter is concerned.
So
now,
so
far as...
What do they want now?
No, my lord, my contention, my lord, I have two contentions. One thing, my lord, this was settled, my lord, on the participation of the Darbars, my lord, way back in 11 March 2021.
But that is what is shown is that there was never any consensus.
My lord, there is, my lord, all the signatories were there. This was done. Now what happened, my lord, with the change, because the election was due, with the coming into force of a new Darbar, my lord, now new Darbar has disagreed. So, my lord, there has to be a finality, my lord, it cannot go on, number one. Number two, other contention is this, any case, my lord, this dispute is now before the district council. My lord, this report and other thing, even under there is a, my lord, well is.
The question of tribunal does not arise here. Why? Because it doesn't fall under establishment of village under section 20.
It doesn't matter if this dispute regarding the boundaries, now that Lat Pasi doesn't want to come in Yalong, is a realignment of boundary. That's the only thing of what you can see from what you read just now. That is just a certain section of Pasi village, that Lat whatever says we don't want to be part of Yalong village. That's all.
Lordship, the entire dispute of the petitioner and the other villages, it falls under section 18 because the Doloi has the power to settle the parties. But if the matter cannot be settled, then the matter has to be referred to the EC.
So you approved it, and then now you
because it was subsequently withdrawn, Lordship, because the Pasi was not. Now Lordship, as per an order, Lordship, by your Lordship's order.
Even then, Suppose this is independent. There was not brought notice of the court that there was already a settlement. Now the thing is that there's already an order. Now before you recall it, shouldn't they be afforded some opportunity?
Lordship, because
Why
when
the
they had
orders
approached,
yes,
Lordship, when they had approached the district council,
they didn't issue notice to them.
no, Lordship. When they approached the district council for recognition of their boundaries, Lordship, no notice was issued.
Village will issue notice. Let them come.
Notice be issued, Lordship.
And if they didn't issue notice, unilaterally they go. The order
It's unilateral, my lord.
is affecting them. Is affecting
And
them
Lordship,
adversely. Then you go and file a petition. Say we didn't agree, and the district council.
Lordship,
just
so far as
repose
the when Pasi village had come before your Lordship, the petitioner has duly received notice, but they have never appeared.
This was disposed of only on the submission while this letter was withdrawn.
Now
No
the
issue.
entire-
I have made it. I have annexed
the
it.
entire
No
matter
issue
is
has been
before
done.
EC, Lordship.
No issue has been decided.
Issue notice, Mr. Eman Umpur is present. Accept notice on behalf of the respondents. 1, 2, 3, 4, 5, 6, 7.
No, 7.
7, my lord. Assuming, my lord, there is a tribunal remit them.
1 to 6.
Respondents 1,
8
6,
also.
and 8.
1 to 6, 8.
Okay, 1 to 6 and 8. Yes, notice issued to the remaining respondents within 3 years. This after 2 weeks. Yes.
9 and 10, your lordships. Go.
Issue notice.
Item number 3.
Obligement.
What is this, Mr. Mitchell?
Lord, the petitioners before your lordship today only for seeking for issuance of notice to the respondents, my lord.
No, what is the matter about?
My lord, the matter is regarding the illegal revocation of permission to the permission and land allotted to the petitioner, my lord.
By whom?
By the respondent, my lord.
Which respondent?
Respondent number 1, Sardar.
What is number?
Number 1, my lord. And along with respondent number 3, my lord. My lord, if you would allow me to present the case, my lord.
Yes.
My lord, the facts of the case is that the petitioner is a retired government servant who has served for the state of Meghalaya since 1981, and he attained superannuation in 2016, November of 2016. Before reaching the fag end of his service, he had intention to further his legacy, which was to set up a tourist spot which is located at Wakaliar. My lord, if my lord would kindly see annexure 1, which is at page 19, which is the application to the respondent seeking allotment of land, my lord.
Okay, no, one thing, Mr. Mitchell.
Yes, my lord.
It's a civil dispute, correct?
Yes, my lord.
Then?
My lord, not only a civil dispute, my lord, the thing is that the petitioner's rights have been violated by the actions of the respondents, my lord. My lord, if my lord will allow me to show, my lord.
Your property,
yes, my lord.
The land given to you.
Yes, my lord.
And then after that, they took it back.
My lord, the petitioner himself was given the land in May of 2016 by the execution of an agreement. Along with all the terms and agreement, my lord, the petitioner since 2016, he has functioned and performed his part of the contract. He has constructed the entire plot itself. In 2017,
with the resort.
Yes, my lord.
It was functioning.
Not almost functioning, my lord. He had constructed the resort, and he was given a confirmation letter on the 1st of January 2017, stating that he is allowed to. He's permitted to. My lord, this is at page 34, and it's just 6, my lord. My lord, I'll read the contents of page 34, my lord. This is a letter issued by the Dorbar Ilaka Nongsteng, dated 5/1/2017. Ha iba sisimor misal. Subject kajingpens kem yakarai Dorbar. Ha kabay day berkatay kapang balakadaw ning. My lord, the important part is this paragraph number 2.
Yes.
Which is tihalor katay kamar kapang balaray balabuah pi kani dorkas. Jingpens kem yakajing ay jaka jungokai patay hapo Wakaliar Ilaka Nongsteng. Thereafter, my lord,
one thing, was it given totally or just leased?
My lord, if my lord will allow me to show your lordship through the agreement, which is at page 22, which begins at page 22, and the relevant portion would be at page 23, my lord. Condition number 3, my lord.
You translated this copy?
Yes, my lord. It's located. The translated copy is at page 26.
Now, where's the condition? You said it's important condition.
No.
At page 24.
Yes, my lord. My lord, at condition number 3, Baka second party. My lord, if I can read the translated version or the Khasi version, my lord, whichever is convenient for your lordship.
No, I can read it.
No.
Okay.
Yes, madam.
As long as you use it, is yours.
As long as we keep one functioning in, it is ours, and it stays with us. My lord, after 2016 and 17, the petitioner has always abided by the terms of the agreement. He has intimated the respondents and kept correspondence with them throughout the entire time. So in 2018, the project was about 85% completed. When he invited the respondents, number 1, 2, and many more other respondents, my lord, this is located at this annexes are located at.
No, there he says functioning golden hour.
Yes, my lord. My lord,
golden hour view.
Our view, my lord. My lord, we would have page 43 also, which would show the local data to tourism. So the petitioner had to cease and stop any operation due to the restrictions imposed by the state. Thereafter, my lord, petitioner was not able to visit his site due to the restrictions. Then the property itself was subject to many antisocial elements where theft had occurred and dacoity also, my lord, destruction of property. So the petitioner by letter dated 28/6/2022.
So no one staying in the property.
There was a caretaker, my lord, who was basically a watchman, my lord, at the resort. So the petitioner, because of the agreement, is also, my lord, there's a condition which says that if there's any dispute that's arising out of the property or anything that arises disputes regarding that, the first authority that shall have jurisdiction is the Dorbar. So the petitioner, by letter dated 28/6/2022, he intimated to the Rangbashnong of Wakalir that these issues were occurring, that theft had occurred, and due to the natural calamities such as the cyclones and all, my lord, there's a lot of damage that he had sustained in the project. The respondents, my lord, did not respond to any of these representation. However, the petitioner always maintained cordial relation, so he sent another letter, which is at page 59, dated 9/9/2023, seeking permission from the.
Only one thing come to the. Now you're not permitted to enter the place, or what's happening?
My lord, that's the thing, my lord. The problem is that the respondents thereafter they told the petitioner to resubmit all his documents and they'll reconsider the entirety again. That is not a condition precedent.
Anyway, we'll just issue notice. Let's see what they have to say, but then I don't doubt whether it's maintainable. Yes, but Mr. W. Mitchell, the petition issue notice returnable in 2 weeks. Steps were taken, but delivered in 3 days. Yes.
Deeply obliged.
Daily list item number 1.
What's the report?
Records are fine.
Delivered. But the service is not complete in respondent number 1.
Number
1.
Number 1, I believe service is not complete. Notes. I am representing number 2.
No, this is what it is delivered or not delivered.
Thank you, records. Return unserved.
Well, we'll ascertain the address because this is the address given in the trial court records.
Yes, the notice to respondent number 1 has returned unserved. After Musika, please allow some time to ascertain the correct address and take fresh steps.
Pleasure.
After 2 weeks.
Interim orders.
Yes, records are received.
The interim order.
Records have also since been received. So, interim order of any shall continue just after 2 weeks.
Item number 2.
I think the petitioner is on leave, my lord. Mr. P. Longbreeze on leave here. I've already filed.
Where is juniors?
I don't see anybody. But I have filed my additional affidavit here, my lord.
Just after, where's he was here just now. He is Mr. Noble Junior, right? Oh, who's there? Pasantio. He appeared last time. Where Mr. Pasantio?
My lord, he is not present today, my lord.
They've received filed additional affidavit. Received it?
No, my lord, we have not received a copy of
You not served a copy?
My lord, the respondent one we have received. My lord, the respondent number 2 had to file the affidavit, my lord.
You're for rejoinder?
My lord, respondent number 2 had prayed for time to file affidavit, my lord.
Yes, okay. Dr. Musica for her from to pray for 2 weeks time to file reply list thereafter.
Item 03.
My lords, I appear for the petitioner.
Yes, what's the matter about?
We were awaiting my lord's present appearance of NMC. On the last occasion, your lordships had adjourned it.
This is what is the matter about?
Admissions of medical students.
Okay.
Yes. There is an interim order permitting all students to continue. On the last date, my lords had directed if NMC does not appear, service on them is complete. If they don't appear, matter would be heard.
You appearing with NMC? Where is this one coming from? Which order was that?
It's just the previous order, my lords. Previous, on the last date of occasion.
Twenty?
21st.
Yes. So you cannot serve them, or they've been served?
They've already been served. Hand summons, Dasti service is also complete.
Yes.
1st of April.
I have received mail
Will appear. Okay, today. The last time, sir, call this matter on 12 June, where parents, one over 2, finish other orders will follow. Yes, today, Dr. Musica, TSGI, has submitted that he will be representing the respondent number 2, National Medical Council. As such, service is complete in all the respondents. Then what do you want? You file affidavit? Yes. We have to adjourn it. He prays for now 3 weeks' time to obtain instructions to file affidavit. Is thereafter. Interim orders are there?
Yes, ma'am.
Interim orders continue in the meantime.
Great, ma'am.
May it please your lordship, there is a connected matter with this which is listed at item number 28.
Listed together on the next date.
Lordship will kindly appreciate if this could be taken up earlier, because our matter is ready for hearing otherwise. And there also NMC has...
No, but then if it's substantially the same issue, then it'll serve no purpose to hear yours first and theirs after. We'll have it after 3 weeks then.
After 2 weeks, if your lordship pleases.
They've already allowed 3 weeks other matter. Yes, 3 weeks. Yes. You file affidavit, then other matter also.
Much. Please. Wait.
Item 04.
Wait, please, lordship. The respondent was supposed to take certain instructions.
May it please your lordship. Lordship, we have conducted the inquiry, your lordships. So the take this copy. This is the copy. I scroll here. Scroll here. Lordship, kindly have that comprehensive summary of the report, your lordship.
Yes.
Lordship, if lordship kindly come to page 4.
Page 4, Your Lordship. That means the grievances of the petitioner has been looked, Your Lordship. Then what happened, Your Lordship? That has been stopped in view of the order passed by the Lok Ayukta, Your Lordship. Kindly come to page 6, Your Lordship.
So first page 4, what you will see?
Page 4, Your Lordship. That is the report, Your Lordship. That is the report, Your Lordship, conducted by the additional district program manager, Your Lordship.
Yes.
Then, Lordship, kindly come to page 5. Lordship, kindly come to the last paragraph.
Oh.
Lordship. Then, because of that, so we stopped the inquiry. Now, Your Lordship, then Lordship, kindly have that another inquiry, Your Lordship. The latest inquiry.
This is conducted by whom?
This is conducted by the Ombudsman of the MGNRGA, Your Lordship, and the District Program Manager, Your Lordship. Lordship, kindly come to page 3.
Once again. Once again.
Lordship, before that, Lordship, kindly come to page 2 of the report.
Yes.
Lordship, kindly come to that observation.
Yes.
That is the grievances of the writ petitioner, Lordship. Observation that construction of approach road 2011, 12, 13, 14. Then, Lordship, there is no signboard. It was also has not been used by the builder and also been hard to access by normal vehicle as the gradient is very steep. There is no signboard of this project. Then, Lordship, all these are the observation. Then, Lordship, kindly come to page 3, the conclusion.
Yes.
Conclusion. As per the report submitted by the additional program officer, Omsning Rural Development Block held on so and so, it may be noted that the spot verification of work inspected on the so and so was completely the same with that of the report submitted from the Omsning since the Omsning team had already contacted with the same may perhaps be referred to the report. That I'll do, Your Lordship. Regarding ICDS building on communication with the CDPO ICDS Omsning, it was verbally informed that the ICDS building was condemned after a joint inspection carried out from the ICDS and block official. It was also informed that it has now
what is the complaint? What is the
Lordship, the complaint, Lordship, kindly come to page 5.
His complaint.
Lordship, his complaint, Your Lordship, yes. His complaint. Then what happened, Your Lordship? What happened, Your Lordship? The newly implemented respondent, Your Lordship, he filed, along with other, he filed a complaint before the Lok Ayukta, Your Lordship. So, which resulted the Lok Ayukta directed for a report for causing an inquiry. That report of an inquiry, Your Lordship, was placed before the Honorable Court, Your Lordship. So, it's all this issue, Your Lordship,
so what do you want from this court?
So, in my humble and respectful submission, Your Lordship, it become infructuous, Your Lordship.
Yes.
It become infructious, Your Lordship. Whatever grievances.
That is not the correct picture. If I may,
You can't use this court just to intimidate.
Whatever,
nothing like that.
And to intimidate and to,
If I may just place my case.
Weaponize.
No, nothing. Nothing of that, Lordship.
Lordship, it is a eco-clash between the former headman and the present headman, Your Lordship.
Yes.
If I may, just 2 minutes, Lordship. I had filed 2 complaints way back in 2023. Those were not answered. I filed this petition only for a simple direction for them to inquire into my complaint.
Now look at the voluminous inquiries have gone into.
Lordship, they have inquired after.
So your contention is not correct. They have not done anything.
Lordship, they have inquired. So
the prayer and
grievance has been.
Lordship,
will not go anywhere. Will not go
In
there.
view of the inquiry, the grievance complaint has been addressed. So we'll.
What do you call it?
Lordship, kindly come to page 25. That is the relief claim in the writ petition.
Yes, the writ petition before this.
Lodge.
It's only for disposal of the complaint.
For disposal of the complaints which have been lodged before the respondent number 2 with regard to the implementation of the MNGRGS schemes in the petitioner's village stop. In the course of proceedings, has come to light that the various inquiries and inspections have been carried out, which is connected to the complaints made by the petitioner. Stop. Next paragraph. Today, Mr. N.D. Shulai has also produced in the inspection report dated 21st May 24, also a comprehensive summary of the reports with regard to the projects which have been undertaken in Nongrim, Nonglado.
If I may just interrupt for 1 second, Lordship.
No,
No, the report is not of 21st May, Lordship. That is my complaint. Complaint is of 21st May 24. Report is not dated, Lordship. Only
this report dated?
Yes, the other one is dated. The complaint is of 21st. Lordship is the report of only for that.
In view of the fact that the complaints of the representatives stress nothing survives consideration, in the present petition the same is disposed.
Obliged, Lordship.
Obliged.
Item number 5.
Please, Your Lordship. I filed the affidavit of service, Lordship, on respondent number 2, Lordship.
What is respondent number 2?
The executive engineer, Your Lordship.
The
executive engineer, Your Lordship, PhD department.
What's the violation?
Contempt, Lordship.
Contempt, yes. Regarding non-regularization?
Yes. Regularization, Your Lordship. Yes.
Yeah, what happened? What is the direction? Where's the order?
To complete the process within 6 months, Your Lordship, from the date of the order.
Where's the order?
Annexure 1, Lordship. Page 10. Page 10.
Where is the delay? When are you going to comply? When complied or
Your
not?
Lordship will be filing our affidavit today in the course of the day for respondent number 1.
Course of the day.
Yes, Your Lordship.
Submits that first on a status affidavit indicating status of service. Affidavit indicating service of notice upon respondent number 2 has been filed. Yes. Such notice complete or respondents. Next paragraph. MS Ilingua learned engineer submits that affidavit be housed upon number 1 be filed in the course of the day. This after 2 weeks is for further orders.
Yes, much obliged, Lordship.
Item number 6.
Please, Your Lordship. My Lord, we have received the affidavit in opposition of the parties, except respondent number 9 who did not appear.
You're supposed to receive specific instructions. What instructions?
No. My Lord, we have not received any notice in regard to the reference. Apart from this, we need to give the rejoinder. We have a.
I mean, now what's the matter about?
It's matter of non-compensation of non-payment of compensation.
Your Lordship, as the matter is pending before the reference court, Your Lordship, this matter may be closed here, Your Lordship.
You go and file an application there.
My Lord, we have not received any notice. Now, my Lord, I have whatever we have informed about the reference, my Lord. Subject matter is different, my Lord. So I have to give the rejoinder.
Okay. Mr. H.R. please to file a short rejoinder to the affidavit by the respondent number
6 to 8.
6 to 8. Stop. This is in spite of the submissions made by MSZE non-considerate that.
6 to 8 is a corporation that I represent.
Yes, no. This is in spite of the submissions of the learned GA that as the matters before the reference court, the petition may be closed up. In the interest of justice, however, yes, Mr. Day, you'll file affidavit, no? Yes, Justice, prayers allowed. This after 2 weeks. You file your
yes, ma'am. I'll do this.
Prayer for rejoinders allowed.
Item number 7.
Please, Lordship. I filed my affidavit this morning, Lordship.
You've already received, Your Lordship. Lordship, I may be allowed. Yes, Your Lordship. 2 weeks' time. Yes, Your Lordship. 3 weeks' time, Your Lordship. The rejoinder.
MSTN Marat. Response allowed. 2 weeks' time for rejoinder. The affidavit filed by respondents number 1 and 2. List on so and so. Yes.
Highly obliged.
8.
On behalf of respondent number 4 and 5, my lord, we have filed our affidavit.
Yes.
Lordship, later MECL also file affidavit, Lordship, because MECL.
You let them file affidavit also?
Yes, sir.
My lord, Mr. Sheikh has also joined my submission saying that the entire issue of payment of the compensation, my lord, here, application, my lord, FEDCO, my lord, if Lordship recollects, he has also. Therefore, my lord, FEDCO was actually considered as a necessary party and notice was issued. The court has waited. So now, my lord, suddenly my other friend is saying that MBCL to file when we have also said he has also agreed with that, my lord.
Because Lordship, unless affidavit filed by the MECL, it will be difficult to file rejoinder, Lordship.
Actually, if there's no affidavit, how do you file the rejoinder?
My affidavit will not decide his rejoinder to the affidavit of FEDCO.
So the MECL's affidavit may not be required, my lord. FEDCO is a main
You understand, but it's been closed down at FEDCO, correct? Last time gave me some submission.
But my lord, at
Yes,
the time,
yes.
at the time of the incident, they were functioning.
My lord, I am representing the PEDCO, my lord. Now the claims is it is a
reply to the refer rejoinder to the FEDCO.
Yes, yes.
What MECL? Okay. How much time? 1 week?
2 weeks, Lordship.
Because I want to plead for further 2 weeks time to file rejoinder affidavit. Or plead for 2 weeks time to file rejoinder affidavit filed by respondents 4 and 5. Prayers allowed. Stop. It's also submitted to MS Arakolni that no affidavit be necessary from the respondents 2 and 3 at this stage.
Lordship, item number 8, 9 and item number 12 connected matter, Lordship. 8, 9 and 12, Lordship.
Okay.
And in all, I have filed my affidavit, my lord.
Very good. Yeah.
Obliged.
Much obliged.
Item number 10.
Well, please, Your Lordship. Lordship, this is a pension matter, my lord. The petitioner retired in the year 31st 3 of 2023, but till date, my lord, the terminal benefits has not been released to him, my lord. And he's in a dire state, my lord. And it seems like the respondent number 5, my lord, who's the relative of the respondent number 8, my lord, he's the one who's withholding the service books of the petitioner, my lord.
What kind of submission is that? Who's relative? How can someone withhold a pension? Personal capacity?
Yes, in personal capacity. He's the, no, not personal capacity, my lord. He's the additional secretary, law department, my lord.
He is related to the number 8.
Yes, because in fact, my lord, if lordship comes to the reply by the department, it has said that the objection was filed by the respondent number 8, my lord, not to release the pension, my lord. So in view of that, my lord, in view of that complaint,
correct. Where's your affidavit?
I haven't filed, my lord. They're asking for the respondent number 8. They're asking for 50% of the from the pension.
Who's respondent number 8?
Respondent number, yes, my lord.
Oh, Lordship, the direction may be given to the department.
No, have you filed the affidavit?
I haven't filed.
No, they haven't filed the affidavit, my lord.
You're for the state?
I'm for the state, my lord.
You have to file it. How you not file affidavit? What direction to 50%? You can't go on that kind of submission.
50% of the pension.
They actually they have filed an application on the 127, my lord, for enhancement, my lord. But on that application, my lord, they have withhold my pension, my lord. And lordship in recent case also have allowed this gratuity also, my lord. At least provisional gratuity should have been released. Leave encashment should have been released, my lord. But till date, after 2 years also, my lord, they still keep it pending, my lord.
Oh, you have concealed the fact, the petition that There's a criminal revision pending also.
No, I've not conceived, my lord. I have enclosed it, my lord.
You see the affidavit.
No, if lordship comes, I've enclosed the order also, my lord.
Of the pension matter. This is.
They have filed an application under 127, my lord. That is for enhancement of the maintenance, my lord. I've been paying the maintenance to the respondent number 8, my lord. And she has no ground to object my pension and other terminal benefits, my lord.
What is order dated 5th July 24?
Lordship comes to annexure 9, my lord, page 34.
Yes.
This is the order, my lord.
1 second. Let's see the affidavit. Let's see your writ petition. Where? Page 34.
Page 34, my lord. Annexure 9.
Yes.
This is an application under 127 CRPC, my lord.
It's been stayed.
This was granted in my favor, my lord. Thereafter, they have challenged it before the.
Has been stayed by the.
Yes, my lord.
By the judges.
But this is in regard to another proceeding, my lord, not in regard to. This is for enhancement of the maintenance amount, my lord. And so long we have been paying maintenance amount.
You file affidavit. Why withholding the pension then? This is it's a parallel independent matter.
That is what, my lord.
If the direction may be given, my lord.
Direction given to
the pension.
In which manner direction be given? You have to come up. Which is made some. You have to reply to the petition. Why the additional law secretary is forwarding him filing affidavit?
No.
Then I will call him here.
He's a relative, my lord. He's the one who's withholding the service books and everything. Because as per the letter issued by the department, my lord.
No, let him file. If you don't have file, affidavit will pass out next day. Mr.
Lordship.
Today's. What is your submission? He said that let him be 50%.
They are actually asking for 50% of the pension, my lord.
Respondent 8. From
Respondent number 8.
We can't pass the order here. The matter is still seized in the.
Lordship.
With regard to.
Pension, my lord.
Maintenance.
Yes. There is in regard to maintenance, my lord. Yes.
That's a different matter altogether.
Yes, my lord.
Well, let his pension be granted, and then whatever maintenance to be, he has to abide with the orders of the.
Yes, my lord.
Of the, where the criminal court, where the 125 proceeding is pending. We take instructions. May someone to take instructions or to file affidavit by the next date. This sort of tweaks positively. Otherwise, it will pass orders.
Lordship.
You can't mix it up.
Item 11.
Yes.
My pleasure. The matter relates to your promotion of an assistant headmaster, assistant teacher to the post of assistant headmaster of the Davis.
415 no appearance. In the hearing is today.
Orders, Your Lordship. Your Lordship, I'm praying for time to file my affidavit.
Yes, by order dated 22/5/2025, it has been recorded that in the event that no appearance is made on behalf of the respondents 4 and 5 next date, the matter should proceed ex parte. Stop today, no appearance has yet been made on behalf of 115. As such, accordingly, the instant matter shall proceed ex parte against the said respondent. Stop. MSN country prays for further 2 weeks' time. How many times you've taken?
Your Lordship, here what's happened is they have taken cognizance of the petitioner's representation and they've conducted an inquiry. So, Your Lordship, I'm just awaiting the outcome of that inquiry.
Yes. You're aware of that?
Yes. Inquiry already completed as per my.
In your favor?
In my favor, yes.
Then let us file affidavit.
Matter already
MS
issued.
Zeri Non-Country Learned GA submits that On the complaint of whom?
The petitioner, Your Lordship.
On the complaint of the petitioner, an inquiry had also since been conducted and concluded. She please be allowed to file an affidavit and also to bring this aspect on record. You file within 2 weeks.
Your Lordship.
At least up to 2 weeks.
Obliged, Your Lordship.
13.
Yes, my lord. I'm appearing for the respondent 5 to 7. We have received our comments, my lord, and we'll be filing a counter affidavit in 2 weeks' time.
Who won't be filing?
You won't file. You won't file or you'll file?
We won't be filing.
You will be filing.
I won't.
Won't or will?
Won't.
He will not.
He will not, yes. There's a song, no, called You Will or You Won't. 1, 2, 3, 4. Yes, MS OI Bank.
Respondent 5 to 7.
Respondent 5 to 7. Please, how much time?
2 weeks, my lord.
2 weeks time to file affidavit stop missing movement on behalf of respondents 1 to 4. So there's no affidavit forthcoming from these respondents. Only after 2 weeks.
Item 14.
Please, Your Lordship.
Yes.
Your Lordship, on last occasion, Your Lordship has directed them to obtain the instruction as regards the status of my resignation.
Yes.
Now, Your Lordship, my friend who is there physically will submit a copy of the appointment order, Your Lordship. The earlier appointment order which was issued to me by the Negrim was cancelled, Your Lordship. And once again, they hold the interview for the same post. And I appeared there, Your Lordship. And this time they have given me 2 weeks time to join, Your Lordship.
Your Lordship, he's on legs before debate.
Has been processed.
Your Lordship, as per instructions, it has been forwarded to the Ministry of Home Affairs.
No, that is the last instructions.
We received the same instructions, Your Lordship. Therefore, as per these instructions, we're required to take some time, Your Lordship. If I could place this before.
If Your Lordships kindly go through this letter after 5, he is therefore instructed to join the post within 15 days of the issue of this orders, Your Lordship. Further, they won't allow me anymore, Your Lordship. And because of this, I am not being able to apply in any other post in any institution, Your Lordship. The petitioner is definitely a bright doctor. He is having a good future. But the problem is that because of this NOC and for non-acceptance of the resignation,
no, we understand. I remember this matter. What does you want to give?
Yes.
No, we can't accept this. We'll have it again after some time. That
Yes, Your Lordship.
15.
Yeah, please, Your Lordship. Your Lordship, I'm praying for 2 weeks' time to file the affidavit, Your Lordship. On behalf of respondent number 4, 5, and 6, Your Lordship.
Correspondent 1 to 2, Your Lordship. 1 to 3. I'm praying some more time, Your Lordship.
The fresh matter?
Lordship.
Not really. Yes. MS Esdhar 1 to 3 and MS LD Sangma 4 to 6. Pray for the 2 weeks time for affidavit. This thereafter and so on.
16.
I've got the status report, Lordship. Your Lordship may peruse the status report.
So this is that matter where I was assaulted on 2 occasions, Lordship.
Yes, I've got the status report. It's almost completed investigation, Lordship.
Then we'll close it.
Lordship, well, we have not been served with the copy of
the
yes.
The remaining investigation is only to record the statement under section 183.
So the steps have been taken. It's not a fact that they did anything.
Let us see the status report, Lordship. Let us obtain instructions, Lordship.
During the course of investigation, so and so and so and so and so, and last 3 lines of that paragraph further apprehensions, someone scoring the position. Almost completed.
Lordship, in that case, let me take instructions, Lordship.
Let's
Lordship may have it next week, Lordship. Also, Lordship, we have taken steps in respect of the private respondents.
This report has been submitted by the learned senior government additional senior advocate, which indicates that the investigation of the case is almost completed and pending for almost completed. Stop. Into the matter as the complaints of the petitioner have been looked into. We'll close it.
Lordship may have it next week, Lordship. I'll take instructions, Lordship, from the line, Lordship.
It appears nothing suffices consideration. Stop. However, Mr. S. Chanda, please be allowed. Please, the matter will listen next week to allow obtain final instructions. That's the matter on next Tuesday.
Hearing. Supplementary list item number 4.
Take your Lordship. My Lord, today my learned friend appearing on behalf of the MTTC is supposed to submit. On the last occasions, my Lord, we have submitted, and the state authorities have also given their submissions, but in the cause, my Lord.
Yes, Mr. Sen.
My Lord, I have roughly about 8 submissions to make opposing the writ petition. For your Lordship's convenience, I have prepared a bullet point. This can be treated as my written submissions as well, my Lord. So,
petitioner joinder, what does it mean?
My Lord?
This first line, petitioner joinder means?
I apologize, no, this I think is a type of joined.
Joined.
Okay. I apologize.
May I have a copy of this?
I'm just getting it a photocopy. My Lord. Your Lordships have it?
Yes.
My Lord. So the first thing, my Lord, is the first point is that there has been a change in the pay scale from the post of supervisor to the post of the assistant manager. Now, Lordships have already are aware of the facts of the case. The petitioner joined regular service, and this is discounting the previous period where she served in the capacity of a contractual worker or in ad hoc basis. So her regular service in a substantive post was that in the post of supervisor from 1/5/1993. The last revised pay scale in that post as on 2010, my lords will find in the second bullet point, 14,000 up to 27,510. And the last drawn pay was 20,230. Thereafter, upon creation of a vacancy in the post of assistant manager, she decided to abdicate the post of supervisor and look for greener pastures in the post of assistant manager. This is a very important point, and upon being successful, she was appointed to the post of assistant manager on 15/11/2010. At this point, my lords, her new pay scale, the upgraded pay scale, was 17,000 up to 33,690. So clearly and undoubtedly, there has been a complete change and upgradation in the pay scale. So she joined a different cadre carrying a higher pay scale. The next, what your lordships will find, this whole issue revolves around stagnation, alleged stagnation for a period where she served in the post of supervisor from 1993 up until 2010.
Yes.
So she was mindful of the stagnation in the post of supervisor, and she decided to leave this post and join a higher post, which had better growth prospects.
Yes.
So whatever stagnation happened only in the post of supervisor.
Yes.
So, my lord, your lordship, there was a reference to FR 23. That was only to get rid of the disparity with the last drawn pay and the new pay in the post of assistant manager. And lordships, can you see the third point? That the ACP scheme, which was implemented by the MTDC, was prospective in nature, and it does not cater, it was not intended to cater to or apply to past cases of stagnation. From the impugned order, we've indicated that the MTDC implemented the scheme prospectively with effect from 7/7/2011. This I've mentioned in the third point in the second bullet point. Third heading, second bullet point.
Yes.
So whatever alleged stagnation took place was from 1993 up until 2010, when she was serving in the post of supervisor, which she voluntarily and consciously left for a better post. And more importantly, my lords, at this point, the ACP scheme had not been implemented by the MTDC. This was implemented only with effect from 7/7/2011. So this was a case of a past stagnation. And in my humble submission, the ACP scheme is not designed to cater to past stagnation, especially in a situation where you have abdicated that post and you move to a higher post by open selection. So this is a special case. The facts are very unique. Then, my lords, will see the third point.
Now, so your contention is a complete break.
In my humble submission, my lords,
A complete
by
break
her
from
own doing.
supervisor to assistant manager is not.
Yes, by her own doing.
Yes.
It's not a case of promotion.
Exactly.
It's a case.
Promotion. Yes.
Yes,
it's a break. It's a totally a different.
Yes, it has to be seen differently.
Direct recruitment.
Yes, my lord.
Yes.
Then point number 4. The ACP scheme, which was implemented in 2011, has been superseded by the MACP scheme.
Okay.
And I'll take your lordships because there are several other intertwining issues. In her writ petition, as she perceives it, she's not asking for any benefits under the ACP scheme. What is being argued today is that the entire focus is now shifted to the MTDC for an alleged benefit after completion of the first milestone of 12 years. But I'll take your lordships to the writ petition and all the documents and representations that have been made to the state government. Their claim is with regard to the MACP scheme. As your lordships are aware, under the ACP scheme, there are 2 benefits on completion of 2 milestones, 12 years and 24 years. On replacement by the MACP scheme, there are now 3 milestones, 10 years, 20 years and 30 years. And that is their prayer in the writ petition. So the ACP scheme does not exist. It's a non-existent scheme. And they're asking for a benefit with regard to a 12 years milestone, which she qualified for in 2005. That first milestone of 12 years was complete from 1993 up to 2005. So in 2023, by this writ petition, they're asking for a benefit which may have accrued sometime in 2005. That scheme is now replaced by the MACP scheme. Now the question arises, can you make a claim in respect of a scheme which is non-existent and which has been replaced by a new scheme? And especially in the manner in which they've designed their prayer and their entire writ petition. I'll refer to one judgment on this point.
Ranjit Samuel.
Yes, my lord. Union of India versus Ranjit Samuel. Internal page 3. Para 12.
Yes.
Let's have it. Para 12. This issue is no more res integra. Recently, this court, in the case of Vice Chairman Delhi Development Authority, decided on 8th March 22, has considered a similar challenge with regard to the employees of the Delhi Development Authority. In the said case also, the employees had contended that they had completed 24 years of service in January 2009, and as such, they were entitled to get the second benefit, financial upgradation, under the ACP scheme. This court, relying on its earlier judgments in the case of so-and-so, observed thus. In the present context, none of the employees actually earned a second financial upgradation. They undoubtedly became eligible for consideration. So what it is trying to say is that these benefits are not automatic. They are not a vested right at all. They only give you a right for consideration, because upon the implementation of the ACP scheme, there is what they're required to do is constitute a screening committee.
Yes.
And then examine the eligibility of each candidate. They undoubtedly make eligible for consideration. However, the eligibility ipso facto could not, having regard to the terms of the ACP scheme, translate into an entitlement. The eligibility was, to put it differently, an expectation to be entitled to the benefits the public employer, here DDA, had to necessarily review and consider the employee's records to examine whether they fulfilled the eligibility conditions, and based on such review, individual orders had to be made by DTA. In other words, second ACP upgradation was not automatic but dependent on external factors. Furthermore, as held by this court in so-and-so, MACP benefits are only an incentive meant to relieve stagnation framed under executive policy. Its continued existence cannot be termed as an enforceable right. And also in this case, like I had just pointed out earlier, the stagnation was not continued. As on the date of implementation of the scheme in 2011, there was no stagnation because she had already opted for a different post by open selection and her pay scale had already been upgraded. Such expectation is akin to a candidate being declared successful in a recruitment process and whose name is published in the select list, that such candidate has no vested right to insist that the public employer must issue an employment letter has been held by a constitution bench judgment of this court and so. Therefore, it is held that employees' contention that they acquired a vested right in securing the second ACP benefit is unsubstantial. The employees in the case approached the High Court complaining that their vested right, which was assumed entitlement to be given by second ACP, was taken away by the MACP, introduced with effect from 1/9/2008 by an order dated 19/5/2009. No doubt, the MACP scheme is an executive order. Usually, such orders are expressed to be prospective. However, the executive has the option of giving effect to such an order from an anterior date, especially if it confers some advantages or benefits to a sizable section of its employees, as in this case. The nature of benefits, as emphasized by this court earlier, were by way of incentives. They are not embodied under rules. In such circumstances, a set of employees who might have benefited from the then prevailing regime or policy cannot, in the absence of strong and unequivocal indications in the later policy, which might be given effect to from an anterior date, like in this case, insist that they have a right to be given the benefits under the superseded policy. Somewhat of a similar situation here. It is a claim with regard to a superseded policy, and that too from 2005.
Yes.
Then a very important and vital issue that requires a lot of focus, my lord, is that there has been an inordinate delay in latches in filing this writ petition. My lords, the petitioner's claim is for the service period of 93-2010, and the first milestone is achieved in 2005. Implementation of the scheme by the MTDC happened in 2011. The first representation that the MTDC received for this particular claim was in 2022, in the month of June. This was rejected in the month of December 2022. The writ petition was filed in May 2023. How do they explain this delay? What is the justification? And prior to this, every effort was made by them to take up the matter for MACP for that milestone of 10, 20 and 30. They were very clear that they are not entitled to ACP because ACP has been replaced, and it was also the understanding of the petitioner that her services with the MTDC from 93 to 2010 have now merged with the state government services. Because Manoj will recall, there was a previous writ petition where she had made a claim with regard to counting her services from 93 for the old pension scheme. So once this was granted, it was in her understanding that this period from 93 to 2010 will now merge, and her services in the government will relate back to 1993. This is her understanding. Because in the previous writ petition, no reference was made to these claims under the ACP or the MACP. As soon as she was successful in that case, she started issuing representations to the state for her MACP under 10, 20, 30. And we'll see when this 10, 20, 30 occurs. 93 to 2003 is her first entitlement on the MACP, first milestone of 10. 2013 is the second milestone of 20 years. And 2023 is the third milestone of 30 years. And I'll show you lordships from her own documents that this is what she has claimed. So there has been an inordinate delay of 11 years in approaching the MTDC for any such claim, assuming that the claim is actually available to her. In service jurisprudence, delay in latches played a very important role, and courts have been consistently refusing to entertain applications where there have been these kind of inordinate delays.
Right? My lord? Is a continuing right? Yes.
Not in my, yes, my lord. It's not a continuing right in this case. It's just an increment. It is not a continuing injury. In fact, my lords, I've just referred to two judgments here. The first one that I'll refer to is Lordship's judgment, Amanda Basaimot, rendered on 6/3/2024. The relevant paragraph is para 10 at page 12.
Yes.
Lordship have it. Para 10 minute. The Supreme Court, in the judgment cited by the counsel for the respondent, namely Bichitrananda Behara versus State of Odisha, report and so, has dealt with the question of delay in laches and acquiescence and has also analysed and quoted extensively other Supreme Court judgments on this aspect. It has been held in para 21 as follows. I'll only read the part which has been emphasized by Lordship. Profitably, we may reproduce relevant passages for certain decisions of this court. Union of India versus Tarsam Singh. To summarize, normally a belated service-related claim will be to which laches and acquiescence are species. Similarly, laches might be called a genus to a species by name acquiescence. However, there may be a case where acquiescence is involved but not laches. These principles are common law principles, and perhaps one can identify that these principles find place in various statutes where which restrict the period of limitation and create non-consideration of condonation in certain circumstances. They are bound to be applied by way of practice requiring prudence of the court than of a strict application of law. The underlying principle governing these concepts would be one of estoppel. The question of prejudice is also an important issue to be taken note of by the court. The next page, the word laches is derived from the French language meaning remissness and slackness. It thus involves unreasonable delay or negligence in pursuing a claim involving an equitable relief while causing prejudice to the other party. It is neglect on the part of a party to do an act which law requires while asserting a right and therefore must stand in the way of the party getting relief or remedy. Acquiescence is writ large in the instant case, coupled with the fact that the non-grant of the additional increment is not a continuing wrong. With the coming into force of the fresh pay revision by way of subsequent recommendations under the 7th Central Pay Commission, further as noted earlier with the release of the required amounts by the MHRD and the chapter having been closed, reconsideration of the claims of the petitioners will necessarily entail an exercise involving the fresh release of amounts under a lapse scheme on a claim which would have been brought before the court at least 12 years ago. The fault being squarely on the shoulders of the writ petitioners, the relief as prayed therefore, in the considered view of this court, cannot be granted at this stage. Here, the delay is 11 years from the date of implementation of the scheme. There's a second judgment. This is a more recent judgment of 2025 of the Honorable Supreme Court. The relevant page is page 11, para 23 onwards.
Yes.
And this, my lord, this judgment deals with a situation where a claim is made with regard to an ACP increment, and again it was rejected on the ground it was belated. Para 23, my lord. In the facts of the present appeal, we find that the respondent had received the second benefit of financial upgradation under the MACP scheme in August 2010 and even the third benefit thereunder sometime in November 2015. She claimed grant of the second benefit of financial upgradation under the ACP scheme due to her in March 2009 as late as in October 2016 by making a representation. Fortuitously for the respondent, she did not have to approach the tribunal for getting her representation decided because within 32 days of receipt thereof, the Deputy Director rejected such representation on 5th November 2016. The due diligence exercised by a conscientious officer who thought it to be his duty to decide the representation but otherwise could well have elected not to examine the same because 1. A stale or dead claim had been raised and 2. The respondent while in service had accepted the benefits of financial upgradation without raising any demur cannot be taken undue advantage by the respondent by urging that the law declared in the aforesaid circumstances would not be applicable in her case because of factual dissimilarities. The self-imposed restrictions in the exercise of writ jurisdiction under Article 2 to 6 of the Constitution, which have evolved from judicial precedents of this court, need not be restated here. Suffice to say, unexplained delay or laches is considered one of the factors which could assume significance in denying relief when the discretionary writ remedy is invoked. In an appropriate case, a writ court may refuse to invoke its extraordinary powers if the applicant's negligence or omission to assert his right combined with the undue delay or laches and prejudice to the other party warrants such refusal. Then please also have page 18. So at page 18, I'll start from the fag end of para 35 onwards, the third line, my lord, in the first paragraph.
You also make it clear.
No, it's at page 18, my lord.
18, yes.
The first paragraph itself, it's a continuation of para 35. The third line, it begins with needless to observe.
Yeah.
Needless to observe, the cause of action cannot be deferred by making a highly belated representation and awaiting its outcome. We also make it clear that different considerations would arise in a case of a continuous wrong, which has to be decided in the light of the decision of this court and so and so. On such premise, as explained above, the respondent should have, if she felt aggrieved by the action of the appellants of granting her benefit of financial upgradation under the MACP scheme, instead of the ACP scheme, availed the remedy before the tribunal immediately after her rights were affected. She ought not to have waited for so long for ventilating her grievances through a belated representation. Filing of such belated representation, which was rejected in no time, did not have the effect of postponing the cause of action and stretching the period of limitation so as to render the OA as filed within time. So, my lord, a similar case here, cause of action arose in 2011 when the scheme was implemented. She was well aware, and she makes her claim only in 2022 for the first time.
Yeah. When she go? She went over to the government service in
on deputation in 2011, and she was absorbed in 2014.
August 2011.
2014, I was absorbed permanently, my lord. In 2011, in the month of August, I have left, my lord, MDDC, my lord.
8th August 2011, on deputation. Then, my lords, the sixth point that I'm raising, this is a technical point. This is on the fact that the MTDC, my lord, being a corporation, should have been implemented by its own name. The only nexus that MTDC has to this writ petition is that the managing director has been implemented. In my humble submission, that is not sufficient. The MTDC, being a juristic entity and a corporate entity, has to be implemented by its very name. It has to be sued in its own name. Please see the cost title, my lord, which is at page 6.
Yes, 6.
Page 6. Kindly see serial number 6. Respondent number 6 is the managing director. Because the only issue that has happened is they issued a representation to me in 22. I rejected that application in 22 itself in the month of December, and that was rejected by the managing director. The MTDC was not made a party. Now, we took that objection at the very first instance in our affidavit. It was expected that they would make amends and implead the MTDC as a party. But in their rejoinder, they say it is sufficient to have the managing director as a party. It is not necessary for the MTDC to be made a party by name. For example, in an arbitration, if lordships are sending companies for arbitration, it has to be the companies by name. It can't be the directors of the company. They are only functionaries of the particular company. It will be very difficult to enforce orders otherwise. Now, on this particular issue, I'm referring to two judgments. Para 12, 13 and 16, my lord, at page 9.
Needs to be noted here.
Yes, ma'am. It needs to be noted here that a legal entity, a natural.
That's a very relevant point also, because MTDC is a.
How do we enforce the order? Now, let's say Lordships grant them some sort of relief, and the relief is not abided by the Board of Directors. Will they run after the Managing Director? And in fact, my lords, it could also be during the pendency of the case that they take a resolution to abolish the post of Managing Director. They will only have directors. How do they enforce the order? Should I carry on with this one?
Yes.
It needs to be noted here that a legal entity, a natural person or an artificial person, can sue or be sued in its own name in a court of law or a tribunal. It is not merely a procedural formality, but is essentially a matter of substance and considerable significance. That is why there are special provisions in the Constitution and the CPC as to how the central government or government of a state may sue or be sued. So also there are special provisions in regard to other juristic persons specifying as to how they can sue or be sued. In giving description of a party, it will be useful to remember the distinction between misdescription or misnomer of a party and misjoinder or non-joinder of a party suing or being sued. In the case of misdescription of a party, the court may at any stage of the suit proceeding permit correction of the cause title so that the party before the court is correctly described. However, a misdescription of a party will not be fatal to the maintainability of the suit proceedings. Though Rule 9 of Order 1 CPC mandates that no suit shall be defeated by reason of misjoinder or non-joinder of parties, it is important to notice that the proviso thereto clarifies that nothing in the rule shall apply to non-joinder of a necessary party. Therefore, care must be taken to ensure that the necessary party is before the court, be it a plaintiff or a defendant, otherwise a suit or a proceeding will have to fail. Rule 10 of Order 1 CPC provides remedy when a suit is filed in the name of the wrong plaintiff and empowers the court to strike out any party improperly joined or to implead a necessary party at any stage of the proceedings. The question that needs to be addressed is whether the Chief Conservator of Forests, as the appellant petitioner in the writ petition appeal, is a mere misdescription for the state of Andhra Pradesh, or whether it is a case of non-joinder of the state of Andhra Pradesh, a necessary party. In a list dealing with the property of a state, there can be no dispute that the state is the necessary party and should be impleaded as provided in Article 300 of the Constitution and Section 79 CPC, that is in the name of the State Union of India. As the case may be, lest the suit will be bad for non-joinder of necessary party. Every post in the hierarchy of the posts in the government setup, from the lowest to the highest, is not recognized as a juristic person, nor can the state be treated as represented when a suit proceeding is in the name of such office posts or the officers holding such posts. Therefore, in the absence of the state in the array of parties, the cause will be defeated for non-joinder of necessary party to the list in any court or tribunal. We make it clear that this principle does not apply to a case where an official of the government acts as a statutory authority and sues or pursues further proceeding in its name, because in that event it will be a suit or a proceeding for or on behalf of the State Union of India, but by the statutory authority as such. So this exception is perhaps for, say, let's say, land acquisition, my lords. So the collector sues in a statutory capacity.
The only thing they should have written is MTDC represented by the managing director. That's all.
That's what they've written.
Just juxtapose it with a service purpose.
But the intention is very clear. When I've taken this plea that the juristic entity has to be made a party by its own name, they have taken a plea that it is not necessary because he represents the MTDC and therefore his participation is sufficient. So that does not answer the query. Usually when we file it, we file MTDC or whatever the corporation may be, and then another, maybe the managing director or the chairman who's representing so and so. There's a second judgment on this particular point is from the Honorable Karnataka High Court. This is a judgment from 2010. So we'll have the next page. The matter coming on for admission, it is to be noticed that the sale deed in respect of the suit property was executed in favor of a private limited company. The said company is not a party to the suit. Though no issue was framed before the trial court in this regard, it was raised as a ground in the appeal. As is evident from the narration in the judgment by the lower appellate court, the suit was bad for non-jointer of necessary parties. It is apparent from the cause title and from a perusal of the sale deed which is produced in court that the property was sold in favor of a private limited company of which the appellant might have been the managing director. This does not make the suit competent, as it was necessary to file the suit against the company and not against an individual, no matter that he was the managing director of the company. The company is an entity which has purchased this property. Therefore, it is necessary to implead the company as a party to the suit. This is a glaring circumstance that is apparent from a bare perusal of the memorandum of appeal and pleadings and the judgments of the court below. Hence, the lower appellate court, not having noticed this glaring circumstance, it would require the lower appellate court to reconsider the effect of non-joinder of the purchaser, namely the private limited company. Accordingly, the appeal does not give rise. Appeal does give rise to a substantial question of law, namely whether the suit was competent against an individual when the sale was in favor of a private limited company against which the suit was intended to be brought. The answer would be a firm yes. The suit is incompetent without the purchaser, the private limited company, being made a party. Accordingly, the appeal is allowed at the stage of admission. The judgment and decree of the lower appellate court is set aside and the matter is remanded to the lower appellate court to consider the scope and effect of non-jointer of the purchaser, namely a private limited company. Similar circumstance, my lord, they impleaded the managing director. Now, I understand what lordships are saying. They have said managing director of so-and-so. That is for the purpose of description. Otherwise, it will be just managing director Shillong. It would have to be managing director of so-and-so company. That does not meet the requirement.
Okay.
Then, my lords, this is another very important aspect. That what was in the mind of the petitioner when she filed this case, and whether she intended to seek any relief against the MTDC. My lord, we'll just have the prayer in the writ petition at page 29. My lord, please see, I'll read from prayer A onwards. Certiorari should not be issued to set aside and quash the impugned letter dated 8/12/21 issued by the Deputy Secretary to the Government of Meghalaya, PNR Department, whereby the respondent authority regret its inability to upgradation of the pay scale of the petitioner to level 18 of the 5th pay commission with effect from August 2019. This is again directed against the state. Mandamus shall not be issued directing the respondent. This is very crucial. Can you see this? Mandamus shall not be issued directing the respondent authorities to give the overdue benefits of ACPS/MACS, they should be MACS, to the petitioner on completion of her 10th, 20th and 30th year of service, MTDC and Raj Bhavan put together. This is in her mind, that she's not entitled, she's not asking for benefits under ACPS. She's asking for the 3 milestones under MACP. Otherwise, she would have said 12 and 24. Then it goes on to read, Mandamus shall not be issued directing the respondent authorities to elevate the pay scale of the petitioner to level 18 as per 5th Meghalaya Pay Commission with effect from August 2019 for which she is entitled to. And then it's D. Can you see how this prayer is worded? Mandamus shall not be issued directing the respondent authority not to act in accordance with the letter dated 19/12/2022, whereby the petitioner's claim of overdue ACPS MACP benefit was rejected. This is where the petitioner has written to me in 2022 and I rejected their claim for benefits under the ACP scheme. But what they're asking for is not setting aside this letter. They're simply saying that don't act in accordance with this letter. The prayer has to be specific, and if we conduct a holistic reading of the entire writ petition and all the prayers, her entire prayer is for MACP benefits, 10, 20, 30. And it's always directed at the Raj Bhavan, not the MTDC. Well, let's then also see the interim prayer at page 32. This will also further clarify the position.
Yes.
Pending adjudication of this petition, your lordships would be pleased to pass such order so as to give appropriate interim relief to the petitioner if necessary by staying the impugned letter dated 8/12/21. Further, the pendency of the writ petition shall not be a bar to consider the overdue benefit of ACP MACP to the petitioner on completion of 10th, 20th and 30th years of her service, and ought to provide the petitioner level 18 scale of 5th pay commission. Her understanding is very clear that her services in the state government will relate back to 1993. Because she understands that's all been combined now. Because after she's been absorbed by the state government, that at anterior period from 93 will be a part of her services in the government. Now, for this purpose, my lord, I'll take your lordships to 2 representations that she had filed. The first is at page 95. Let's have it.
Yes.
Page 95. This is a representation dated 23 June 2021, which the petitioner wrote to the Honorable Governor of Meghalaya. Please see page 96, para 4.
This is 28 January. No, this is?
No, well, this is 23rd. It's in the top left corner.
It's stuck with the...
Yes.
Yes.
So at page 96, para 4, my lord, that though I have completed a total of 30 years of service under the government of Meghalaya, please take note, this is her own submission. I have completed a total of 30 years of service under the government of Meghalaya. Unfortunately, I did not get any benefit of the Assured Career Progression Scheme during the period of my service. She claims that she has served 30 years in the government of Meghalaya. This is her understanding. Then there is another representation dated 6/2/23 at page 109. My lord, submit. So this is again a representation dated 6/2/23 addressed to the Deputy Secretary to the Governor of Meghalaya.
Yes.
Please see page 111. 111, para 9. This reads that the undersigned will be completing 30 years of service with the state government in May 23, and as per 4th Pay Commission, she is eligible for ACP after 12 years for having completed in 2005, 20 years having completed in 2017. So she's back and forth on what she's actually entitled to. But she claims that this entitlement is from the state government, not from the MTDC. Then also in the same representation,
yes,
please see page 115. So there is a inherent contradiction even in this particular representation. So at page 115, para 29. It reads that keeping in view the above facts and circumstances, the number of years of service rendered by the undersigned, the job responsibilities and the enhanced qualification of Master Degree in Tourism Management, the undersigned prays for justice from the competent authority in relation to 1. Her overdue ACP MAC benefits on completion of 10, 20 and 30 years to be completed on 31st April 2023. So yet again, she's claiming ACP benefits from the state government. So I had understood from the very first day that they had directed their prayer against the state government. On the last occasion, they sort of changed course to focus on the MTDC for some reason. Now, on this point, my lord, I'm referring to a judgment this is on the question of the nature of the prayer in a writ petition.
I mean, no relief sorting assembly. What is the place? No relief sought against MPTC.
No relief has been sought. So, if your lordships read the entire writ petition wholesomely, your lordship will find from the representations, the prayer and all of it, that there is no relief actually sought against the MTDC. And there is no specific prayer. And it's not just a case of a typographical error or something not being worded properly. From an overall understanding of all the representations, it's very clear that they want entitlement from the state government for the 3 milestones, 10, 20, 30. They have no claim on ACP. That is their case. We'll see page 246 of this judgment.
So that means here they have concerted, it's a concerted move.
Yes, my lord.
To avail of MACP.
Lordship. And lordship will recall the first day, their entire claim was MACP, which is why they were directing it against the state government. And I'll take your lordships to one last submission that I have.
Page 20?
Page 246.
Yes.
Para 29 onwards, my lord. Para 29 to para 37. My lords have it?
Para 37.
29 onwards. The approach of the High Court in granting relief not prayed for cannot be approved by this court. Every petition under Article 226 of the Constitution must contain a relief clause. Wherever the petitioner is entitled to or is claiming more than one relief, he must pray for all the reliefs. Under the provisions of the CPC, if the plaintiff omits, except with the leave of the court, to sue for any particular relief which he is entitled to get, he will not afterwards be allowed to sue in respect of the portion so omitted or relinquished. Though the provisions of the code are not made applicable to the proceedings under Article 226 of the Constitution, the general principles made in the CPC will apply even to writ petitions. It is therefore incumbent on the petitioner to claim all reliefs he seeks from the court. Normally, the court will grant only those reliefs specifically prayed for by the petitioner. Though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, grant a relief not even prayed for by the petitioner. Is there a prayer saying that the order of the MTDC should be set aside and they should be directed to release the increment available to her with regard to the first financial upgradation under the ACP? There is no such prayer, my lord. Then please see page para 31. In Krishna Priya Ganguly versus University of Lucknow, overlooking the rule relating to grant of admission to postgraduate course in medical college, the High Court, in exercise of powers under Article 226 of the Constitution, directed the medical college to grant provisional admission to the petitioner. This court set aside the order passed by the High Court, observing that in his own petition in the High Court, the respondent had merely prayed for a writ directing the state or the college to consider his case for admission. Yet the High Court went a step further and straightway issued a writ of mandamus directing the court to admit him to the MS course, and thus granted a relief to the respondent which he himself never prayed for and could not have prayed for. Again, in so-and-so case, it has been held thus: a party cannot be granted a relief which is not claimed if the circumstances of the case are such that the granting of such relief would result in serious prejudice to the interested party and deprive him of the valuable rights under the statute. Though a High Court has a power to mold reliefs and to meet the requirements of each case, that does not mean that the draftsman of a writ petition should not apply his mind to the proper relief which should be asked for and throw the entire burden of it upon the court. Then please see para 35. Respondents 1 to 6 were seeking a writ of certiorari or mandamus to declare that the order dated 5/7/2008 passed by the learned Chief Judicial Magistrate Disa, refusing to hand over custody of the goats and sheep seized to them, was illegal, and were also seeking quashing of the said order. At no point of time had the learned advocate for respondents 1 to 6 moved an application seeking permission of the court to amend the prayer clause contained in the petition so as to enable respondents 1 to 6 to claim compensation from appellant 1. And then please also see para 37. There is no manner of doubt that the High Court was too indulgent in this matter. After all, it was not a petition from a person languishing in jail, or from a bonded labourer, or a party in person, or public spirited citizen seeking to bring a gross injustice to the notice of the court. Here the High Court had before it respondents 1 to 6 as petitioners. The question whether respondents 1 to 6 suffered damage or loss because of handing over of goats and sheep to appellant number 1 and to respondent 8 depends upon the facts to be proved. Normally, such an exercise cannot be undertaken in a writ filed under Article 2 to 6 of the Constitution. So, my lord, upon a wholesome reading of the plaint with all their perceived understanding of their case, no relief was ever sought against the NTDC. It was not even intended. Well, yes, it was not even intended. Never intended.
Never intended.
Never intended, my lord.
So they can't seek half reliefs.
Yes, and what would be the relief then? What they're asking for is issue a mandamus directing them not to act in accordance with my rejection letter. What does that mean? What would that really entail? They're not asking for recovery of that particular increment, the financial upgradation. No prayer at all. The prayer is for the 3 benefits, 10, 20, 30 under the new scheme. That's all.
So they can't maintain the prayer of ACP.
At least as against me. Now, and this is further compounded by the fact that there's a huge inordinate delay.
Yes.
And also under a replaced or superseded scheme.
Anything else?
Yes, last point, Milords. When my learned friend had started off on the first day, I recall, he had referred to these guidelines considered under the MO. Please have page 68
of the writ petition.
Milords. This is an annexure to the ACP scheme.
Conditions for grant of financial
Yes, my lord.
obligation.
My learned friend had read out para 3 and para 5. Para 3 relates to counting of regular service. These provides the eligibility conditions, and para 5 with regard to past service.
Yes.
Although this again will have no bearing on me, but I have some interest because what is being projected is that the corporation is a department of the government. This is not correct, my lords, legally. May I just read, my lords, para 3 onwards. Counting of regular service for the purpose of the ACP scheme shall commence from the date of joining of a post in a direct entry grade on a regular basis, either on direct recruitment basis or on absorption re-employment basis. Service rendered on an ad hoc regulation 3F contract basis before the regular appointment or pre-appointment training program shall not be taken into reckoning. However, past continuous service in another department of the government, please mark this expression, my lord, another department of the government of Meghalaya, in a post carrying identical scale of pay prior to regular appointment through proper channel in a new department without break shall also be counted towards satisfying regular service for the purpose of the scheme only. The state government in the affidavit maintains that the past service in the corporation from 93 to 2011 cannot be included for the purpose of granting any benefits under the ACP scheme. My learned friend has argued that the expression another department.
5, that past service autonomous.
Yes, I'm coming to that. So what my friend is suggesting is that this expression another department of the government includes the corporation as well. Then also see past service, my lord. Past service rendered by an employee in another state government, statutory body, autonomous body, public sector organization before appointment in any department of the government of Meghalaya shall not be counted. So they make a clear distinction between department of the government of Meghalaya and a PSU. If the intention was to include PSU in the department of the government of Meghalaya, they would have included that in para 3 itself. My learned friend for the state had already referred to a judgment. I am referring to just 2 judgments, my lord, which are specifically on this point.
What argued for the state?
Mr. Tripathi. Mr. Tripathi had argued day before yesterday, my lord. He had also maintained that a PSU is not a department of the government. It's not part of the state because it has its own autonomy.
There are many other judgments also on this point.
Yes. This I'm just referring to 2 paragraphs, my lord, para 9 and para 10, which is at page 69 and 70. At page 69, para 9, my lord.
Yes.
Learned counsel for the appellant then urged that the corporation is a government department. We are unable to accept this submission also. A government department has to be an organization which is not only completely controlled and financed by the government, but has also no identity of its own. The money earned by such a department goes to the exchequer of the government, and losses incurred by the department are losses of the government. The corporation, on the other hand, is an autonomous body capable of acquiring, holding and disposing of property and having the power to contract. It may also sue or be sued by its own name, and the government does not figure in any litigation to which it is a party. It is true that its original share capital is provided by the central government and that 11 out of 12 members of its board of directors are appointed by the government. But then these factors may at most lead to the conclusion, about which we express no final opinion, that the corporation is an agency or instrumentality of the central government. Then please see the next page, page 70, para 10.
Yes.
Even the conclusion, however, that the corporation is an agency or instrumentality of the central government does not lead to the further inference that the corporation is a government department. And my lord, one last judgment on this specific point. Because the relevant portion is at page 777, para 13.
Yes.
Good. Upholding the objection and considering the ambit and scope of Article 311, this court held that an employee of a corporation cannot be said to have held a civil post and therefore not entitled to protection of Article 311. According to the court, the corporation could not be said to be a department of the government, and employees of such corporation were not employees under the union. The corporation has an independent existence, and the appellant was not entitled to invoke Article 311. So to sum it, my lords, the case, there is no prayer against me, I am not a party, and there is a highly belated claim which cannot be entertained. Obliged.
Any reply? Second half.
Yeah, yes, my lord. I'll take some time because my learned friend has exhaustively argued on so many points.
Another date.
That would be, in fact, more convenient, my lord, because your lordship. I'll leave it to you now, my lord.
No, of course, you'll have the right to reply. Yes, can't shut you down. You take a date. When can you come? But not too far away. Otherwise,
my learned friend would be available next week.
I'm here.
Next week. Next week, before 19th, will it be convenient for my lords?
19th of
June, of course, my lord.
Next week is? Yes, we can have it on
19th will be difficult for me, my lord. On, my lord, 17th? No, my lord, on 18th will be difficult because I have some other preoccupations also. Or after 19th, or 19th. 19th, I will not be there, my lord. So any date post 19th or before 19th.
They will have it on 24th.
Yes, my lord. Tuesday, my lord.
Yes, at length. Just for further hearing on 24. You understand on which?
Yes, my lord. A brief.
Reply.
What they are trying to suggest is, my lord, that the state authorities, which on the other day they were trying to, my lord, shirk from their part and say, my lord, that they are not responsible. Now they are saying that my prayer is only confined to my lord. And anyway, so far as, my lord, the delay part is there, my lord, I'll explain, my lord, because in the pleadings, my learned friend has gone beyond the realms of the pleadings, because there is not even iota whisper in the pleadings itself for that point he has raised, my lord. So anyway, my lord,
but that is a point of law.
Of course, my lord. But the pleadings has to be clear. If he's
discretion of the court on the other hand.
Yes. All other matters. Anyone ready for hearing? Then second half.
I'm obliged, my lord.
Yes,
deeply obliged.
Second call. Item 14. 14.
Joint prayer for item number 18.
You just wait some time. What? Any hearing is ready? Any hearing ready for second half? We'll take up second half.
Matter.
Khan looks ready.
Item number 6.
Supplementary item number 6 may be disposed of
in view of the
order passed by the managing director, my lord. There's a claim to the interest, my lord, on the gratuity. So.
Oh yes, we'll sit suspecting.
In view of the order passed by the apex court letter. So subsequently, they have issued the.
Yes, record in item number 6.
6 supplementary.
Yes, supplementary list. In view of the decision of the whose decision this?
My lord is from the managing director Macofet.
Of the respondents. 1 crore 13 lakhs.
My lord.
Dated 4th April 2025 with regard to the interest on the gratuity.
Yes, my lord.
Yes, nothing survives the consideration. It is the same scores. Copy of the decision dated 4th April is taken on board, made part of the record.
Obliged.
Item number 23 may be taken up after 2 weeks, Your Lordship.
Yes.
Item number 23, Your Lordship.
Do it after second half. What's the problem?
I have little difficulty. So,
what
if this matter may be taken up after 1 week, Your Lordship.
What difficulty? You're allergic to this court.
No.
Then? Last time you asked to take time and then you were waving to me in the road. And he said that he's got personal difficulty, he's not well. You remember that day, correct? Yes. Yes, call it order matter. The order item, where's that?
14.
Where's Dr. Mozika? After 1 week, I can do. Yes. Yes.
The instruction I placed, my lord.
Dr. Mozika,
from Assam Rifle, we have sent it to Ministry, my lord, because it will take some time, my lord.
No, we have to pass orders on this matter.
Lordship pass an order then.
They
cannot come with like this, my lord. There is a procedure, there is a time frame for everything, my lord.
No, again, it's very appointed.
My lord.
May I respectfully submit, your lordship? With your lordship's kind permission.
Yes.
Your lordship, the director, he is.
Now this is given to you on 10th. 10th is how many days you have to join?
Within 2 weeks, your lordship. If your
Okay,
lordship
you come on Monday. We'll hear this matter.
But my instruction that we will need for
Monday you fix it, Dr. Mozika. Even if there's a process that can be expedited. Yes, instructions have been received.
But by this writ petition cannot be monitored, my lord, everything, because this is again a different cause of action.
It's a question of monitoring. It's a question of once a resignation will be given, if it's due to resign.
My lord, as I placed, my lord, there is no absolute right of resignation, but this is subject to acceptance, my lord.
It's not been argued, but the thing is that consideration. Whether you reject it or you allow it. That's what the court wants to see that. Rejected
then. My lord, on 28th, we have sent it to Delhi Ministry, my lord. Ministry's approval is required, that was placed on last occasion also.
No, but 28th then.
28th, we have sent it, my lord. Most probably it will done, but it will need some time, my lord.
No, why they have sent so lately, your lordship? When the matter was given only on 1st, why they have sent it so lately, your lordship? Your lordship will fix it on Monday, and your lordship will call the DIG.
Yes, Monday.
It's going overboard, my lord. This people.
Let him go overboard. He's playing to the gallery, yes. Huh? The other 2 hearings, who's ready will have it in the second half. Yes.
18, 27.
18. The second half.
My lord, let this matter come up next week, my lord. I have some difficulty in the second half, my lord. My lord, this matter relates to dismissal from service.
Police?
Police, my lord.
And police will take 5 minutes. All the police cases are kind of hopeless cases.
My lord, I'll try to make a case on 2 points, my lord.
27.
This is the matter from Lady King College regarding the dismissal.
Where's
of
Mr. He'll have it at 2 o'clock. No, it's only nearly 2 o'clock.
When don't want to have it. We're already keeping your lordships beyond lunch.
1 week after. Yes, as Mr. S says are available, this is matter up to 1 week.